New court ruling. 5. Gun laws changed. Almost nobody noticed. The Supreme Court ruling just changed how 5 major gun rules work in real life. And if you still think an unfinished kit is just parts, you could be trusting old information that no longer protects you. Pause. Quick question before we continue. Are you subscribed? Because these legal shifts do not come with a warning label, and missing one update can put a normal gun owner, builder, or seller in serious trouble. Hit that subscribe button right now so you stay ahead, not behind. Here's what just happened. The ruling is called Bondi versus VanDerStok. Most people heard the words ghost gun case, shrugged, and moved on. Big mistake. Because this was not just some narrow fight for lawyers in Washington. This changed how federal law treats gun kits, unfinished frames, private builds, and even what dealers have to do when certain homemade guns come through the door. Let me break this down for you in plain English. The court did not pass a brand new law. That part matters. What it did was say the federal government can treat some unfinished gun products as firearms under rules that were already on the books. In other words, the words in the statute stayed the same, but the line moved in a way that changes what you can buy, sell, ship, and build without hitting federal paperwork. First thing that changed, some full gun kits can now be treated like actual firearms before you even assemble them. That is the part that shocked a lot of people. Most gun owners think a box of parts is just that, a box of parts. But the court said if a kit has what you need to become a working gun, and it can be turned into one quickly with common tools, the government can regulate it like a firearm. That means the old, "it's not assembled yet" argument is much weaker than it used to be. The court pointed to a kit that could be built into a semi-automatic pistol in about 20 minutes. Think about that. Not a full machine shop, not a master gunsmith. A novice, common tools, short time. That was enough for the court to say, yes, at least some kits fit the law. Why does that matter to you? Because a lot of people buy based on labels and marketing words. They see parts kit, build kit, or unfinished, and they assume that means no firearm rules apply. Here's what most people get wrong. The label on the website is not the final word. The real question is how complete the kit is, how fast it can become a working gun, and how easy the build is with ordinary tools. Here's a hypothetical example to explain this. Let's say you order a kit online. It comes with nearly everything needed to build a pistol. The seller calls it a build package, not a gun. You assume it can ship like random hardware. But if that package is close enough to a working firearm and easy enough to finish, federal rules may treat it very differently than you expect. Now, this is where it gets interesting. Second, the ruling also changed how unfinished frames and receivers are treated. A frame or receiver is the main core part of a gun. Think of it like the skeleton that holds key fire control parts in place. The court said some partially finished frames or receivers can be regulated too, even if they still need a little work. That means a part does not have to be totally complete to cross the legal line. The opinion talked about a nearly finished frame where a few tabs could be removed and a few holes could be drilled in minutes. Again, the theme was speed and ease. If a beginner can finish it quickly with everyday tools, the government has a stronger argument that it counts. But wait, there's something even more important. The court did not say every chunk of metal or plastic is suddenly a gun. And that distinction matters a lot. Raw materials are still raw materials. A block of metal is not the same as a nearly finished frame. Liquid polymer is not the same as a near-ready receiver. That line still exists, but it is not where many people thought it was. So the first 2 changes are huge. Some kits can now be treated as firearms, some unfinished frames and receivers can too. And if you miss that, the rest of the dominoes start falling. If you're finding this helpful, imagine what you'll learn in my next video about the exact mistakes gun owners make when they trust forum advice over court rulings. Subscribe so you don't miss it, because one bad assumption in this area can snowball fast. Third change, sellers of covered kits and covered unfinished core parts can be treated more like gun dealers than part sellers. Let me explain why this matters. An FFL is a federal firearms licensee. That's just a simple way of saying a federally licensed gun seller or maker. Before this rule got upheld, some businesses argued they were not selling firearms at all. They said they were only selling parts, blanks, or starter items. After this ruling, that argument is much harder to use when the product is close enough to a working gun. So if a business is dealing in kits or parts that now fall inside the definition, licensing rules can kick in. That means the business may need to follow the same type of federal system you usually expect when actual guns are sold. And yes, that changes the market even if you never build anything yourself. Why? Because availability, shipping, record keeping, and transfer rules all get tighter when a product moves from parts into firearm territory. Fourth change. Serial numbers and record keeping now matter in more situations than many people realized. This is the part nobody's talking about. Once a covered kit or covered frame is treated like a firearm, Ordinary compliance rules follow right behind it. That can mean serial number requirements, dealer records, and background check procedures in the normal sales process. So even if your mindset is, I'm not buying a complete gun, the law may answer back, that does not matter if this item qualifies anyway. And here is where people really get blindsided. Not all privately made firearms are illegal under federal law. That part is important. If a person lawfully makes a firearm for personal use, federal law does not automatically require that person to put a serial number on it, as long as other laws are followed and the person is not making guns as a business for profit. A lot of people stop listening right there and think they are safe. But here's the catch. If a federally licensed dealer takes a privately made firearm into inventory, that dealer generally has to mark it with a serial number within 7 days, or before it is transferred out, whichever comes first. So the legal issue may show up later, not just at the build stage. Imagine you built something for yourself years ago, no sale, no business. You think the story ends there. Then later, you bring it to a dealer for resale, consignment, pawn, or maybe repair that turns into inventory. Suddenly, federal marking rules become part of the conversation. That is why old advice can get you in trouble today. Now, quick legal note, this is educational information, not legal advice. Always consult an attorney for your specific situation. Fifth change, the ruling made one thing very clear, and this may be the most important part of all. The safe line is not whatever the product is called. The safe line is how a court may view how complete it is and how quickly it can become functional. That means words like 80%, unfinished, or DIY are not magic shields. They are marketing words. And marketing words do not control federal law. Courts do. Agencies do. Facts do. If the item is basically a short walk away from being a working gun, you are in a very different legal world than someone holding a true raw material or a standalone part. Hey, a huge chunk of people watching right now are not subscribed. Don't be part of that group. Join the gun owners who get these updates first. Because these quiet rulings can affect what you buy, build, and keep long before the average news story catches up. Click subscribe. Now, let me show you the part almost nobody noticed after the headlines faded. The Supreme Court did not say the government wins every future fight over every product. That is a big deal. This ruling was what lawyers call a facial challenge. Here's the simple version. The court was not deciding every possible product one by one. It was deciding whether the rule was invalid across the board. The answer was no. Why do you care? Because that means future product-by-product lawsuits are still possible. A company may still argue that its specific blank, casting, or unfinished part is too incomplete to count. A buyer may still argue a certain kit is too far from a working gun to fit the rule. So yes, the government won this round in a major way. But no, every single future case is not automatically over. But here's the crazy part. That uncertainty can make things even harder for regular people. When the line depends on how readily something can be converted, people start guessing. And guessing around gun law is dangerous. Have you ever noticed how fast bad legal advice spreads online? Somebody posts, relax, it's just a paperweight. Another person says, my buddy ordered one with no problem. Then 10 more people repeat it like it's gospel. Meanwhile, the real legal question is much more specific. How complete is it? How easy is it to finish? What tools are needed? How long does it take? Is it sold with the other needed parts? Those details matter more than internet confidence. Here's what most people get wrong now. They think this ruling only affects hardcore hobby builders. Not true. It can affect online shoppers, small sellers, local dealers, pawn shops, estate transfers, and even people cleaning out inherited gun parts, who have no idea what category something falls into. Let me break this down with another simple example. Say your uncle passes away and leaves behind boxes of gun parts. You find one unfinished frame, one parts kit, and a few random components. Most people would toss it all in the same mental bucket. But under this ruling, those items may not be treated the same at all. A standalone barrel is one thing, a raw block is another. A nearly finished frame is different. A complete kit that can become a working pistol quickly is different again. If you don't know the difference, you can make a costly mistake before you even realize that there was a legal question. And remember, the court also made clear that not everything is covered. Standalone triggers, barrels, stocks, and magazines were not swept in by this rule just because they are gun parts. Raw materials were not magically turned into firearms. That matters because fear can spread just as fast as bad legal advice. The truth is in the middle. The rule is broader than many gun owners thought, but it is not unlimited. So what should you take away from all this? Stop relying on old category labels. Stop assuming unfinished means unregulated. Stop thinking personal use, dealer transfer, and resale all play by the same rules. They do not. This information can shift again if Congress rewrites the law or if later cases carve out specific products one by one. Subscribe now because the next update in this area may not make front page news, but it could still change what is safe to buy, keep, or transfer. So here's the bottom line. This ruling did not ban every homemade gun or every unfinished part. What it did do is move 5 major legal lines at once. Some kits can count as firearms. Some unfinished frames can count too. Sellers of covered items face stronger licensing pressure. Serial number and record rules reach farther, and the old labels many people trusted no longer mean what they think they mean. Pause. If this helped you cut through the noise, subscribe right now and send this video to one gun owner who still thinks unfinished automatically means unregulated. I make these videos so you can protect your rights without stepping into avoidable trouble. And one last thing, this was simple educational information, not personal legal advice. If your situation is specific, local, or urgent, talk to a qualified firearms attorney in your state before you act. The Supreme Court decision in Bondi versus VanDerStok has set a new precedent for the ATF. This shifts the definition of what constitutes a firearm in the eyes of the law. Many manufacturers will now have to adjust their production and sales strategies immediately. Consumers should be aware that their previous purchases might now be classified differently. Law enforcement agencies are also being briefed on how to handle these new regulations on the street. The distinction between a part and a firearm is now more about potential than current state. If a piece of hardware can be converted into a functional weapon with ease, it is now under scrutiny. This ruling specifically targets the ghost gun market that has grown rapidly over the last decade. However, the legal battles are far from over, as individual states may impose even stricter rules. It is vital to check your local laws, as they often vary significantly from federal guidelines. The ATF has already begun updating its internal guides for field agents regarding kit inspections. Many online retailers have started pausing sales of certain products to evaluate legal risk. If you currently own a kit that fits these new descriptions, consider seeking legal counsel. The goal of these updates is to keep you informed so you can remain a responsible and legal gun owner. Don't let a lack of knowledge result in a felony charge or the loss of your rights. Stay vigilant as the legal landscape for builders continues to evolve month by month. Make sure to share this information with your local range or hunting club members. Thank you for watching and for doing your part to stay informed on these critical issues. We will continue to monitor the courts and provide updates as soon as they become available. Until next time, stay safe and stay legal in everything you do with your firearms.